Okay, everyone. So we're going to go ahead and call Senate Revenue to order. Mr. Secretary, please take the roll.
Senator Dennis. Here. Senator Ratty. Senator Kieckeffer. Here. Senator Severs-Gansert. Chair Neal.
Thank you. Mark Senator Severs-Gansert absent, excused. We are going to go ahead and just call the meeting to order. I'm going to open up the hearing for AB 414 and call Assemblyman O'Neill to the table.
Thank you, Chair. Good afternoon to the Senate Revenue Committee members. I want to wish you all a wonderful afternoon. I know it's been a little difficult today, actually, for me after our police memorial, but I do appreciate it. I'm Assemblyman P.K. O'Neill. I represent Assembly District 40, which encompasses all of Carson City and the southeast part of Washoe County. I'm here today to present to you Assembly Bill 414, a bill which deals with the exciting parts of Nevada probate law. That's why I brought chocolate also. Sweeten you up, hopefully. But anyways, the intent of today's proposed legislation is basically a housekeeping effort to clean up inconsistencies within statutes of Nevada law related to the transfer upon death of real property of relatively small estates. Section 1 is an effort to clear up an issue with the mechanism necessary to file a death deed, which is a tax-exempt action. Currently, the procedure is to initially file an affidavit of death of the grantor with the appropriate county recorder's office after the death of the grantor, then file a deed of death, which is taxed in some counties and not in others, which is the confusion. It is this tax which is unfair to the grantees, I believe. Section 2 is to decrease the 18-month waiting period required before the beneficiaries can attain clear title to sell their real property and bring it into accordance with other probate timelines. The challenges faced by the heirs is that during this 18-month time period, which allows for potential claims to be filed by possible creditors, is that they have to continue to pay the various taxes, utility bills, mortgage maintenance, or upkeep expenses, all to maintain the property value. Additionally, insurance companies won't provide homeowners insurance on a house which is left vacant after 60 days. In conclusion, AB 414 is our chance to clear up the language and bring the deed of death transfer into conformity with other estate transfer mechanisms within Nevada revised statutes. I have with me today two experts in this field who will discuss and be available for questions. Mike Pavlakis of counsel with Allison McKenzie Law Firm, Carson City, who will discuss Section 1, and Richard Staub of Richard Staub and Associates Law in Carson City, who will discuss Section 2. And upon your desire, Chair, would you like them to actually go through the two sections, or would you just like to go straight to questions and answers?
I want them to go through the two sections.
Thank you. Then I'd like Mr. Pavlakis to come on and discuss Section 1 first, and then we'll have Mr. Staub do Section 2.
Thank you, Assemblyman O'Neill. My name again is Mike Pavlakis, and I want to thank Assemblyman O'Neill for bringing this issue forward. And Madam Chairman and members of the committee, it's my honor to appear before you today. I asked Assemblyman O'Neill to bring this forward because of an experience I had last year when a family came to me whose father and grandfather had passed away. And the grandfather, using his own devices and the tools available under the Nevada statutes, had availed himself of a deed upon death. So grandfather had recorded the deed upon death during his lifetime, and his desire was to transfer his home, which was valued at approximately $200,000, to his 2 children and his 1 grandchild. His grandchild happened to be in college under the age of 21, but over 18. So the family came to me and they thought they needed a probate. We found that Grandpa had a bank account at a local bank that had $20,000 in it. He was living on Social Security and retirement benefits. Those benefits ended with his death. So he didn't have a large estate. He had his house, $200,000 house, and a $20,000 bank account. I said, well, you don't need a probate. And the good news is that your dad and your grandfather did a great thing by doing the deed upon death. He didn't have to have a lawyer. He didn't have to have a trust. He didn't have to have a will. He used the tools that are available to him under the statute. And when the decedent recorded the affidavit or the deed upon death, he paid a $43 recording fee to the county recorder. There was no transfer tax due because NRS 375.090 sub 10 specifically exempts a deed upon death from the payment of transfer tax. So I helped the family with the preparation of the statutory form of the affidavit of death. Again, that's a form that the legislature has provided for in the statute. I told them they could do it on their own, but I was happy to help them. And we prepared the document. I told them there was going to be a $43 recording fee. We took the affidavit of death with the death certificate to the county recorder. And ultimately, the county recorder's position, initially the position was that the entire value was subject to tax. But then the county recorder said, well, no, because there's a transfer from father to children, there's no tax due on that portion. But the transfer to the grandchild, there's no exemption for that. And notwithstanding the language of the statute that says that there's no transfer tax for a deed upon death, the county recorder's technical reading was, but we're recording an affidavit of death, and therefore there's going to be a transfer tax due. This transfer tax was due from a student who's in college who had little ability to pay that tax. Now, if Grandpa had prepared a trust and paid a lawyer anywhere from $3,500 to $4,500 to prepare a trust, there would have been no transfer tax due. If Dad had prepared a will and that will had gone through probate, and the probate order was recorded with the county recorder's office, there would be no transfer tax due. But because this gentleman took advantage of the specific statutes that this legislature has adopted, the grandchild in effect was penalized because his grandfather didn't have the means to hire a lawyer to set up a fancy trust or a will for him. And that to me just seemed wrong. I reached out to the district attorney, who agreed with me but said that he had to support the position of his client, the county recorder. I reached out to Assemblyman O'Neill and Senator Kekeffer, and I truly appreciate the work that particularly Assemblyman O'Neill has undertaken on this bill. If there are any questions on Section 1, I'm happy to try to answer them.
Members, any questions on Section 1? So I had a question just on the time period. So you chose the 90 days because you said it was 18 months?
Madam Chair, if I may, that'll be in Section 2.
Oh, okay.
Section 1, really the only change in Section 1, if you look at the bill itself, will be on page 3, line 19 and 20.
Oh, yeah, I am reading.
That
I'm
clarification.
looking at the notice. Sorry. Go ahead and explain Section 2.
We'll go to Section 2 then. Mr. Staub?
Yeah, members of the committee, my name is Richard Staub. I'm an attorney here in Carson City, practicing law for 45 years. I hate to say that. but it does date me a bit. And again, I also thank Assemblyman O'Neill in bringing this bill forward for my request. I do a lot of small estate planning for clients here in Carson City and surrounding areas. And I do a lot of deed upon deaths for those clients. It's a very simple process that this body passed in 2011, wisely so, that allows individuals with small estates, house, like most people have, to transfer that house upon the death of the grantor by merely filing an affidavit of death of that grantor. The problem with the statute and what this bill is all about in Section 3, and I'm addressing Section 3, is that there's a waiting period of 18 months, or there's a period of 18 months that individuals can file claims against the states that don't have the enough assets to pay those claims. And the problem that these people run into when dad or mom have died is the title company takes a look at it and says, you're going to have to wait 18 months or you can dispose of the property. And some of the title companies, I understand, are even waiting 24 months. And as Assemblyman O'Neill pointed out, this is a long time to have beneficiaries wait. And as Assemblyman O'Neill pointed out, they've got to maintain that property for 18 months. And I, in my practice, just believe that is defeats the purpose of having a deed upon death at all. So I approached Assemblyman O'Neill and he agreed to come forward. And what this Section 3 actually does, that, and I will say from Section 3 through Section 7, is merely make a deed upon death comport with other probate laws that are currently in effect in the state of Nevada. For example, a standard probate under NRS 136 there's a notice to creditors for 90 days. Under NRS 145, which is a summary administration, the notice is 60 days. If you have a trust, the notice is 90 days notice to creditors. And so what this does is it requires the beneficiaries from a deed upon death to file a notice to creditors by mailing that notice to individual creditors they know about, and to also publish that notice for a period for once a week for 3 weeks, and provide notice to the public that any person that has a claim against the grantor's estate needs to come forward within 90 days to file that claim. One other thing that it does, this amendment does, that doesn't exist in law, is it requires the beneficiaries to provide a notice to the Department of Human and Health Services to allow them the ability to determine whether the grantor ever received public assistance. And if he did, or she did, then the claim could be filed, and ultimately the beneficiaries are going to have to recognize payment of that claim by the Department of Health and Human Services. This provision doesn't exist in law at all. And it's kind of a loophole, because I've talked to the people at the Department of Health and Human Services, and they basically find out these people die by getting the information through vital statistics or notices that they may determine through county recorders. So I've discussed this bill with representatives of VHHS, and they're neutral on this bill, but they understand that now they're going to get some notice. So that's what basically Section 3 and 4 do. The notices, the format for the notice is provided. Under Section 5 provides that anybody that has a claim has 90 days after the first date of publication or mailing to file that claim, where it's forever barred. Section 6 basically states that when they provide notice, beneficiaries provide notice to DHHS. DHHS has 45 days to advise the beneficiaries whether the grantor did receive public assistance, and if he or she didn't, then the Department of Health and Human Services has to provide what they call a waiver of claim. That will allow the beneficiaries to dispose of the property. All occurs very quickly, between 45 and 90 days after the death of the grantor. Certainly not a year and a half, which I think is just simply egregious. The other thing that it also does under Section 8 is it title companies, the Land Title Association, I did contact them, and it basically allows the title companies to look at a deed upon death and recognize that the notices that are provided under this amendment are notices that they can rely upon under Nevada law. And it also states that the title companies are not going to be liable for claims which they are not made aware of by the beneficiaries. And then subsection 9 is something that the Land Title Association asked that we include, and it merely allows the title companies to deal with beneficiaries in deeds upon death just as if they were dealing with distributee in a normally probated estate, so long as the people they're dealing with are acting in good faith, and of course they file that affidavit of death of grantor. So that's the sum and substance of the amendment. It is a cleanup, but it also is more than just merely a housekeeping bill. So that's my presentation, Madam Chair, and I'll stand for questions.
Members, any questions? So I know I initially had a question on Section 6, which was the Section 2, Sub 6, about the property transfer by the deed, because it seemed to be not just the initial transfer, but like the subsequent transfer. And I guess I was trying to get an understanding, because that seemed to be the new part that's in NRS 222-29306. And so I wanted a little bit more conversation about that, about the property transfer. So how would that affect somebody who, they could be a beneficiary, but they could have had a life estate, and now the property has potentially been transferred to them, at least for their life, and there may be debts associated with the property?
Well, the current law, Madam Chair, this is Richard Staub for the record. The way the law is currently written, an individual generally goes to a lawyer. They don't have to go to a lawyer. They prepare a deed upon death, which basically states that upon their death, property will transfer to generally their children or their wife, and they file that deed with the recorder's office and pay a filing fee for that, and it basically sits dormant until the grantor passes. Grantor can sell the property, they can mortgage the property. That death deed is not going to stop them from doing that. Once the grantor dies, then the beneficiaries, the deed is obviously discovered, and the beneficiaries under the deed will file an affidavit of death of grantor and be able to proceed to dispose of the property. The 18-month period basically is a roadblock for them to be able to dispose of the property, because the title companies simply won't issue a title insurance policy for that transfer. This bill basically cleans that up and brings it into, makes it consistent with current probate law, or general probate or trusts requires the beneficiaries to provide a formal notice to creditors and a published notice to creditors. And once that's done, the beneficiaries can dispose of the property. They can use the property. They own the property. It's not a life estate. They own the property in perpetuity or until they pass themselves. And they would have the ability also to either sell the property or execute their own distribution on death deeds, transferring the property potentially to their children. I don't know whether I answered your question, but I hope I did.
So you kind of did, but I'll just leave it there. So I don't see any additional questions, so we will go to support for AB 44. Oh, well, Senator Ratty has a question.
Well, apologize, and not being the brilliant legal mind that my colleague who chairs this committee is, I just need a little bit more concrete examples. And I guess I've been blessed to not have to deal with the passing or probate process of anybody at this point in my life. And so could you just give me examples of who the debtors would be, like in the most concrete way, that would be interested in a typical probate, and a little bit more about DHHS? What benefits would they be trying to recover?
Richard Stock for the record. The DHS is trying to recover potentially Medicare, Medicaid, probably Medicaid, public assistant type benefits that the grantor may have received. For example, if they went into an assisted living home and there was no provisions made regarding how a lien might be filed against the grantor's property, that wasn't taken care of. It would give the DHS people the ability to file a claim to recoup the benefits, the public assistance they paid on behalf of the grantor out of the assets, home of the grantor when it's potentially transferred by the beneficiaries. Other claims against the grantor could be simply debts of say, credit card debt. It could be medical expenses. The mortgagee on the home would be able to formalize their claim. I mean, that's a public record, so it's really not that it's probably not that big of an issue, but it's the non-reported types of debts that the grantor had or accrued during his lifetime that have not been paid. And this amendment will require some type of notice to the public, to those creditors, so that the beneficiary simply can't dispose of the house and escape the liabilities that the grantor created during his lifetime.
Thank you. That helps to make it a little bit more real for me. And I'm just trying to remember. So in Medicaid eligibility, basically a person has to get to a point where their income level is particularly low. And from an asset standpoint, their assets have to be low, but we allow them to keep their house until such time as they pass, and then all of the benefit needs to be paid back. Is that how our Medicaid system works?
They would have to negotiate the liability that DHHS claims. And DHHS informed me that while they try to get 100% of the liability, they realize that people may not have that kind of money. So they have to basically negotiate their liability with the beneficiaries.
Okay. So fair to say a more sophisticated, legally sophisticated family that is using the more robust tools of trusts and other things may be escaping some of that recapture of the debt. And this tool on its face is just more simple, and so therefore is not used in that way. Is that an accurate reflection?
That's correct.
Okay. Thank you for helping me understand that.
My pleasure.
Thank you for that. Senator Dennis, did you have any questions on 414? Oh, okay. So we will go ahead and open up for support on AB 414. BPS?
If you would like to offer support of AB 414, please press star 9 now to take your place in the queue. Once more, to offer support of AB 414, please press star 9 now. Thank you, Chair. It appears there are no callers wishing to offer support at this time.
Okay, opposition?
If you would like to speak in opposition to AB 414, please press star 9 now to take your place in the queue. Once more, please press star 9 now to take your place in the queue to voice opposition to AB 414. Thank you, Chair. It appears there are no callers wishing to voice opposition.
Okay, so let's go to neutral.
To voice neutral testimony to AB 414, please press star 9 now. Caller with the last 3 digits, 186. Please state and spell your name for the record. You may begin.
Good afternoon. For the record, my name is Tiffany Lewis, TIFFANYLEWIS, and I'm an Administrative Services Officer with the Division of Healthcare Financing and Policy. I'm here to testify in the neutral position on AB 414 and confirm that the division has removed the fiscal note associated with the original draft of the bill. We would like to thank the sponsor for his willingness to work with us to ensure the bill did not have a negative impact on the Medicaid Estate Recovery Program. Thank you.
Thank you, Chair. There are no other callers to offer testimony at this time.
Okay, so we will go back to the sponsor of the bill, Assemblyman O'Neill.
Thank you, Chair. And normally, in this case, more is less, but I do just want to say that Senator Ratty really brought forth one of the main crutch of what I'm trying to do with AB 414 is those smaller estates, the small person, I guess, with limited income, to make it simpler and easier for them to pass what little they have is in real property, is their house, on to their heirs. So I ask for your support of this bill and moving it forward, and I do appreciate the time that you've given me. Thank you very much.
Thank you for that. Commend your efforts. All right, so we'll close the hearing on AB 414 and open up for SB 423.
Thank you, Chair Neal and Vice Chair Ratty. For the record, my name is Melanie Young, Executive Director for the Nevada Department of Taxation. And with me here are members of my team, Chief Deputy Shelley Hughes and Deputy Director Jeff Mitchell for Local Government Services. This bill, SB 423, is the result of the department when we were faced with budgetary reductions. Our executive team met to look at alternatives to proposing something other than budget cuts. Our budget is primarily funded with general fund dollars, and our largest expenditure is personnel. In reviewing alternatives, the executive team has 3 revenue proposals that are being introduced this session. This first bill, SB 423, which proposes a commission to compensate the state for services of providing the valuation, billing, and collection in relation to centrally assessed property. This service is provided by our Local Government Services Division, and at this time I would like to turn it over to Deputy Director Jeff Mitchell to walk through the provisions of the bill. Thank you.
Thank you. Jeff Mitchell for the record. As mentioned, I am the Deputy Director over Local Government Services in the Department of Taxation. Centrally assessed properties are companies that owe property taxes to entities they reside in, but are of an interstate or an inter-county nature. The type of companies that this includes are railroad companies, airline companies, or utilities that cross state or county lines. Currently under NRS 361.320, 361.321, and 361.3205, the state values and develops the assessed values for these companies, bills, collects, and then apportions the taxes on the centrally assessed property for the benefit of the local entities. In Section 1, the proposal in Senate Bill 423 will allow the Department of Taxation to retain a commission as compensation of certain costs of administering the centrally assessed property tax. This commission would be in the amount that the legislature specifies, but the department is proposing a commission currently equal to the cost of administering the valuation, billing, collection, and disbursement of the tax on the unsecured property of centrally assessed. At this point, I would like to turn the time back over to Director Young, who will provide some details on the mechanisms and how this would work.
Thank you, Melanie Young, Executive Director, for the record. What's being proposed here is something that is very similar to the way the department currently handles the tobacco taxes and license fees that are found in NRS 370.260. The way this works is during the biennial budget process, the department would review the cost for the evaluation, billing, and collection of the taxes. We create a spreadsheet that is included in the budgetary process that calculates personnel and operating costs. These costs are then included in our agency request budget and reviewed by the Governor's Finance Office during the Governor's recommends budget, and then the Legislative Council Bureau fiscal staff to validate the costs, the calculation of the cost. And then the amount that the department would collect as the commission would be approved through that budgetary process. The legislatively approved amount would be applied to the taxes collected on a proportionate share of the revenues. The commission's proposed on this legislation for fiscal year 2022 is $135,992. And in fiscal year 2023, that amount is $137,928. To provide an additional point of clarification here, these services are provided by the department on behalf of the counties, and it is provided with 100% general fund dollars. Additionally, I would like to point out that if in the future biennium, a change to the allocation that includes the amount or the department would propose maybe increasing positions or different things like that, what would require the department to do is we would have to put that any increase over what is currently being requested in an enhancement decision unit that would provide a decision point for the legislature. Section 3 of the bill has an effective date of July 1, 2021, and this concludes our presentation, and we're available for questions. Thank you.
Thank you for that. Questions from committee members? Senator Kekeffer.
Thank you. Thank you, Madam Chair. Thank you, Director Young. So the amount that's going to be set budgetarily is specifically related to the assessment and collection of this specific tax. It won't bleed over into any other work that the division does.
That is correct. We did a time study. We looked at the positions that do the work. Sorry, I apologize for the record, Melanie Young, Executive Director. And so, yes, we looked at the positions that actually do this work, and that's how we have supported the costs and what we're proposing here today.
Okay. And as I recall, this is consistent with how we closed the budget for your department. Is that right?
Yes, Melanie Young, for the record, that is correct.
Thank you.
Any additional questions? So I had one question on the, I guess it was the enhancement statement that you made. You said this would, it sounds like you would have to, you no longer would have to then put in an enhancement request. But my question is, would you still have to at least put in information to give knowledge to the IFC or the legislature about how much you used out of the money? Like, let's say the legislature decided, okay, you can use 4% or 5% or whatever, and you use 3%. What then is your role to then let the legislature know how much you used in that allocation?
Thank you, Senator Neal, for the question. Melanie Young, Executive Director, for the record. To clarify my comment about the enhancement is during the budgetary process, anything more than what we're currently calculating as a result of this request would require the department to put that in an enhancement decision unit, which would give the money committees the ability to make that decision point of whether or not to approve any increase to what we're currently doing. So to clarify, any position or any costs that are fringe related or as a result of any cost allocations that are outside the department's control. Those would be able to maintain in the department's base budget. And so I think to further answer your question, at the end of every fiscal year, the department, what we do on tobacco is that we take a look at our actual cost. So our actual cost, the budget is 100,000 and our actual costs are 90. We only accept the 90,000. That's what we currently do for the tobacco. And then the rest would be redistributed back to through the process.
So thank you for that. And so just a quick follow-up. Have you had a conversation with the counties about, I know it's centrally assessed property, but it's also inter-county, but have you had a conversation with them about what the effect would be of you taking that commission and what are they losing?
Yes, Melanie Young, Executive Director. For the record, thank you for the question, Senator Neal. And yes, we have met with NACO and provided them with a spreadsheet of what it would cost as if it were to be administered today. So that could change over time because we don't know when the budget is set. The amount in the budget for our cost would be set, and then every year when we set the rates or set the assessments for the centrally assessed, that could change. And so based on, it would be a proportionate share. And so, yes, we did provide that information to NACO and others that had joined in some calls with us.
So can you state what was the perceived loss? I didn't see any exhibits.
Yes, what I would like to do is if I could have Jeff Mitchell, if he has the ability to share his screen, he can pull up a spreadsheet that we've created and share that if you'd like.
Thank you, Chair Neal. The total loss would be equal to the amount that we're asking through on the commission. So it would be a total of that 135,992 for FY 2022. And that would be spread out among everyone that has a property tax rate that those certain properties touch. And so I can bring up the spreadsheet, but it's quite a large list of entities, and I hope that it carries through on the screen if you wish to see so.
Thank you for that. The only thing I would really wish to see are, I guess, the effect on smaller counties, because that 135,000, technically, if we were talking about Eureka, well, maybe Eureka. Let's do let's do a Eureka. So if you could show me a smaller county, what would be the effect of the loss, right? Sometimes $100,000, it's a service. And so I really need to understand, the impact upon them. I understand why you're doing it, why the Department of Taxation wants to do it, but I also want to understand the reverse effect on the county.
Absolutely. Let me see if it'll allow me to share. I hope so. Did that come forward? If not, I can speak to the county level. So Eureka County in total for FY 2022 would be $683.71. And for FY 23 would have been $693.45. And that would be spread out among the different entities within Eureka County, the cities and so forth that have that property tax rate. And did it share?
Yeah, you can take that down. I mean, unless we had super goggles like Superman or something, we'd know the way we'd be able to see that.
My sincere apologies.
So, but I did have a question because in relationship to this inter-county discussion that I'm having with you, the bill also, and then I was looking at NRS 361320, it seems to also cross interstate. So that's different. And so, I mean, that's what I'm looking at it, but it seems like it's inter-county and interstate. interstate?
Yes. Jeff Mitchell again for the record. So the properties that we're looking at on the centrally assessed roll, they encompass both those that are cross inter-county, so those could be smaller utilities that are fully enclosed within the state of Nevada, or they could be larger companies which run nationwide. And part of the valuation process that we go through is then figuring out the amount of property tax that is first due to the entire state of Nevada, and then due to with each entity within that state that those properties or companies operate.
So thank you for that. I just need you to put a little bit more, because it's the same conversation I just had with you about the inter-county reverse effect. What then is the interstate? And what was the notice or conversations that you guys have been having with that crossover? And can you put a little bit more information on the record of, I guess, geographic locations that we can visualize in our minds around the interstate component of this provision?
Yes, and thank you, Jeff Mitchell, again for the record. So without naming a specific company, for example, if you looked at the railroad companies that operate nationwide, the valuation that we go through on that is we value that company as a whole unitarily. And then we figure out just the amount of operating property within the state of Nevada. And so when it's mentioning interstate, there's not really necessarily a lot of correlation with the other states and the amount of taxes due. Those companies have to interact with each state that they operate in. And we apportion it the amount of value of the entire company that is just attributable to Nevada, and then break that down further to each entity that has a property tax rate that company operates in. I hope that helped clarify.
It does. And so, because the valuation as a whole and is very important part, I think, in a very important component to the bill. And so when you talk about like the railroad, what is the apportionate value of the railroad to Nevada? What's the company called? What's the name of the railroad company? Southern, okay. Because there's two, right? There's two. There's see, they're talking about Polar Express. Anyway, so I wanted to, let me clean this question up. Can you talk about the apportionate value that Nevada has for the railroad company, since you are evaluating it as the entire company?
Yes, and that is a matter of public record. When we do value these companies, much like any other property tax that is out there, the valuations and then the apportionment is there. So if you will give me just 1 second to go specifically to those companies. I apologize, I did not have it on the tip of my tongue here.
Well, if you had another one like the utilities, right? I mean, because the utilities are in there, and that probably has a much higher valuation if you're taking the entire company.
Yes. So, for example, my apologies, Jeff Mitchell, for the record, with the Department of Taxation. For the 2021-22 centrally assessed roll, the statewide value for Union Pacific Railroad was $410 million approximately. And then we apportioned that out based upon the counties that they operate in, the assessed value for the different counties. And that information is available on our secured roll bulletin, which is published on the taxation website.
Thank you for that. Because I guess I'm looking for the number, right? Because I'm not going to go to the page. Not right now. If you could share what that 410, so if it's 410 million, and then you said that's a portion across the counties, right? That's what I heard you say.
Mm-hmm.
And then what is the dollar amount? I'm making you breathe hard. Okay.
Thank you. Jeff Mitchell, again, for the record. I would have to get back with you with the total dollar amount. So how we then look at that 410 million, for example, 22,800,000 is assessed valuation of that 410 is owed to Churchill County. And that would be applied against that property tax rate in those specific areas that railroad operates in there. And so it's almost more of a specific bill for county and then apportioned out to the entities from the county treasurers.
Okay. I'm saying wow, because now I understand why certain parties are interested in how this is going to play out for them. But I really wanted you to put that on the record because there is I would say there's some significant money that's at play and people wanting to understand the mechanics of it and what this commission piece will take away from them, being that you intend to keep it. So, members, any additional questions? Okay, so I guess no more questions. So we will open up for support for SB 423.
If you would like to speak in support of SB 423, please press star 9 now to take your place in the queue. Once more, that's star 9 now to offer support for SB 423. Thank you, Chair. There are no callers wishing to offer support for SB 423 at this time.
Okay, so we will go to opposition, which I believe is in person, and then we will go to BPS.
Good afternoon, Chair Neal, members of the committee. Dagny Stapleton, D-A-G-N-Y-S-T-A-P-L-E-T-O-N, Executive Director of NACO, the Nevada Association of Counties. I want to start by thanking the Department of Taxation for the communication on this bill. Early on at the beginning of session, Director Young, Deputy Director Mitchell, and Chief Deputy Hughes reached out to NACO and a few of our members, and we had a call with them, and they explained that this bill was coming and what the intent was and what they were seeking to do. So we appreciated that communication, so we were not surprised by this. And then the bill came out a few weeks ago, and we have spent some time over the last day or so talking with taxation staff about some changes we were interested in seeing. So we want to thank them for that. Our concern and the reason that we're opposed today is that as drafted, the bill doesn't specify how the new commission or assessment, as we usually call them, will be calculated. Specifics of maybe a formula, how it's tied to, or whether there's a limit on how much it can increase. As you all know, there are a number of assessments that counties are subject to, and many of them do have details or formulas so that there's a certain predictability for counties on these, year over year and biennium over biennium. We did request of taxation that they add language to the bill, perhaps putting a cap or an otherwise more specific formula so that we could have more certainty. So that's our request to them. I believe that they were looking at some language to potentially do that, but not sure if that's possible or if there's interest in doing that. So without that, we are opposed, but we are hopeful that we could work with taxation on getting some language just to provide more certainty and more clarity on this amount and the amount going forward for counties. Appreciate the willingness to provide testimony, Chair Neal, and I'd be happy to answer any questions.
Thank you for that. Members, any questions? Senator Kieckhofer.
Thank you, Madam Chair. Have you done an analysis of the potential cost to each of the individual units of government? And if so, what's the largest single hit that any unit of government is going to take?
Thank you. Chair Neal, through you to Senator Kieckhofer. The department did provide us with a breakdown early on also. The Department of Taxation indicated that was the case, and I believe overall it's like $130,000 somewhere in that ballpark. I don't have the exact number in front of me, distributed over all counties. So literally a very small amounts. Of course, the largest to Clark County for their share, but I think that even that's under $100,000. So not a whole lot, which is why our main reason for opposing and request is the change in language and the certainty or formula or cap.
Thank you for that. Okay, so BPS, is anyone on the line for opposition?
If you would like to offer opposition to SB 423, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 666. Please state and spell your name for the record. You may begin.
Good morning, Madam Chair, members of the committee. Warren Hardy, W-A-R-R-E-N, last name Hardy, H-A-R-D-Y, today representing the Urban Consortium, which is made up of the cities of Las Vegas, Henderson, Reno, and Sparks. We would just simply like to associate ourselves with the comments of Ms. Stapleton and NACO, both relative to the willingness of the staff at the Department of Taxation who has worked with with members of our consortium, and but we share the exact same concern with relation to how this is set up without any cap on expenditures. And I won't belabor it, but we feel the same as they do regarding that. That's the only reason for our objection. We have no objection to the department retaining a reasonable commission for providing the administration of these services. So thank you, Madam Chair. I appreciate the opportunity.
Thank you for that. BPS, any additional callers?
Thank you, Chair. There are no other callers to offer testimony at this time.
Okay, so we'll go to neutral.
If you would like to offer neutral testimony to SB 423, please press star 9 now to take your place in the queue. Thank you, Chair. There are no callers to offer neutral testimony at this time.
Okay, Department of Taxation, any closing comments?
Yes, thank you, Chair Melanie Young, Executive Director for the Nevada Department of Taxation. And I would like to thank NACO and the others that have reached out to talk with the department about an amendment to this legislation that would provide a cap. And I would just like to share at this time my concerns about putting a cap on this legislation, which may cause a budgetary burden to the department. For example, if the cap is a percentage base, the state budgets are set 2 years in advance and even before the full assessed value is determined. If the assessed value were to decrease and a cap is in place, the department may not be able to accept the full commission that is budgeted by the legislature. When this was originally proposed, we based the example on the fact that an 8% commission is what the counties are able to retain for doing very similar work. We feel that the budgetary process, as this would provide the department to place an amount over and above that is currently calculated or being proposed here, would be done in an enhancement decision unit, and that the very thing that the local governments are concerned about, that enhancement decision unit would hold the department accountable for any amount over and above what we're currently asking for. The department would have to come forward and justify to this body and defend the cost. And so that is our concern about adding a cap to this legislation. We are hopeful that we can come to some type of resolution, but I think coming to a very small or an amount that would put a cap would put an undue burden on the department as well as the legislature. And thank you.
Thank you for that. So we will go ahead and close the hearing for SB 423. We will open up for public comment. BPS, is anyone on the line for public comment?
No, Chair. The public line is open and working. However, there are no callers at this time.
Okay, so we will go ahead and adjourn Senate Revenue.